Sync copyright infringement in social media posts by brands. The ubiquitous enforcement fight by music right holders is on. In today's digital first marketing landscape, music plays a central role in shaping the identity and emotional impact of brand content on platforms like Instagram, TikTok, and Facebook. But with this creative opportunity comes significant legal risk, particularly when popular music is used in brand or influencer content without the necessary synchronization, also called sync license. This article explores, and this podcast episode explores the legal framework governing sync copyright infringement in social media posts, highlights recent enforcement trends and case law from jurisdictions, including the US, the UK, France, and Germany, and offers practical guidance for both brands and right holders navigating this increasingly scrutinized space. So what's going on? What is the landscape? In the age of ubiquitous digital content, music is more accessible than ever before. From Instagram Reels, Facebook posts, and TikTok clips to brand-sponsored stories and YouTube ads, music underpins the emotional tone of many social media communications. For brands, using popular music tracks in social media posts has become an almost reflexive marketing tool. This synchronization of video content into audio content is called in the music business synchronization, also called sync, S-Y for Yahoo, N-C-H, or just sync, S-Y-N-C for short. However, this surge in music usage has led to a worrying trend: widespread and often unlicensed use of copyrighted musical works, particularly by brands seeking to amplify their reach in social media videos. What seems like a harmless 15-second clip can in fact constitute an act of copyright and neighboring rights infringement. Indeed, sync copyright infringement refers to the unauthorized use of music in timed relation with visual content, such as videos, advertisements, social media posts. This area of law sits at the intersection of copyright, commercial licensing, and digital content distribution. Many brands assume that simply purchasing a platform license, such as TikTok or Meta business account, is sufficient to cover all legal bases, i.e. that they will also automatically get a synchronization license relating to their use of music accessible from the music libraries of those social media platforms. But these social media platform licenses never extend to the commercial use of music in brand-driven campaigns or to sync rights for promotional posts. This is clearly explained by Meta in its Instagram terms of use on its web pages called Access to the Licensed Music Library on Instagram, and audio you can use in your reel on Instagram, and how to make sure that content you post to Instagram or Threads doesn't violate copyright law. Meta is also crystal clear in its Facebook terms of use on its webpage Music Guidelines. Similarly, TikTok has some music terms of service and commercial music library user terms, complemented by the webpage Commercial Use of Music on TikTok, which clearly set out that music users must secure a prior license from the right owners if they want to use a music track for commercial use in their TikTok video content. So what are those brands missing doing in this synchronization process? They are not securing a sync license prior to using the music track for commercial purposes on their social media platforms. So what is a synchronization license? A synchronization license, commonly called a sync license, is a contractual agreement that allows the user, typically a video producer or brand, to use a copyrighted musical composition in timed relation to moving images. This license is typically required from the owner of the musical composition, usually a music publisher or songwriter, and the owner of a sound recording, usually a record label or artist, if the original recording is used. Using a copyrighted song without such permission constitutes infringement under UK, French, EU, and international copyright law. Under the UK Copyright Designs and Patent Acts 1988, unauthorized use of a copyrighted work, such as reproduction, communication to the public, or making available online, can trigger civil liability for infringement of a musical composition covered by Section 16 and 20 of the UK Copyright Design and Patents Act 1998, infringement of the sound recording if the master is used, also covered by Sections 16 and 20 of the CDPA 1988, and moral rights violations where applicable. Similar provisions apply under the French Intellectual Property Code, Code de la Propriété Intellectuelle, in particular Article L122.4 of the Code de la Propriété Intellectuelle, which sets out the general principle of authorization. This is a foundational article stating that any use, reproduction, or performance of a protected work without the rights owner's consent is unlawful. Article L122.2 of the Code de la Propriété Intellectuelle relates to the rights of representation. This grants authors the exclusive right to authorize or prohibit public performance or communication of their work, including broadcast via digital means such as social media or video platforms. The right of reproduction is covered by Article L122.3 of the French Intellectual Property Code, and it relates to the fixation of a work on any medium, including synchronization with video, i.e., such as embedding a song in an Instagram or TikTok reel. There might even be some civil and criminal sanctions for infringement under French law, such as civil damages, injunctive reliefs, but also some criminal penalties sometimes. The neighboring rights for phonogram producers are covered by Article 123.1 of the French Intellectual Property Code, and when the original recording is used, not just the musical composition, this provision protects the rights of the record producer or label. They must also authorize any sync use. And also, the neighboring rights for performers are protected by Article L216.1 of the French Intellectual Property Code. Similarly, performers must authorize any fixation and communication of a performance as used in the recording. Similar provisions apply throughout the EU member states under the InfoSoc Directive from 2001. Yet, brands very often overlook reading these music terms of use from their social media platform of choice, let alone the provisions from the Intellectual Property Acts or codes which apply in their respective jurisdictions, before impulsively posting commercial videos synchronized with music tracks such brands find in the music libraries of such social media platform. The result? A growing number of infringements that threaten the economic livelihood of rights holders, including music publishers, record labels, and independent artists. Sync copyright infringement is increasingly common on platforms like Instagram, TikTok, and Facebook, where businesses use trending music to promote products. Often, businesses mistakenly believe that music made available via Meta or TikTok's internal library is free to use for commercial purposes, or removing the post cures the prior infringement. These are misconceptions. As explained before, most social media platforms only secure limited end-user rights, not full commercial sync rights. Used by a brand or company for promotional content, particularly if reposted or boosted, is always outside the scope of any platform license. So how are music right holders fighting back? In response to this systemic misuse, music rights holders are increasingly taking structured legal steps to enforce their rights. Many have implemented monitoring systems, employing tech tools and legal advisors to detect unauthorized uses of their repertoire on social media platforms. When infringements are identified, the standard course of action is to issue a formal letter before court action. These letters typically outline the nature of the copyright, moral rights, and neighboring rights infringement, the relevant legal framework, such as unauthorized reproduction, communication to the public, or making available rights, and the rights holders' expectations, usually an immediate takedown request of the infringing reel or post, failing which the rights holders will request a court injunction, and a settlement offer that covers past damages, a penalty fee for not securing a sync license prior to publishing the social media content online, and secures undertakings for the future. Some right holders offer structured licensing agreements to resolve the matter amicably. Others propose one-time settlements, depending on the scope and gravity of the unauthorized use. The emphasis is often on resolution before litigation in compliance with the civil procedure rules, and practice direction on pre-action conduct and protocols in the United Kingdom, which makes pre-action conduct compulsory, and with the provisions of Article 751 of the French Civil Procedural Code for disputes where the value of claims is equal to or below 5,000 euros. Indeed, right owners may pursue damages or an account of profits, injunctions to restrain further use, public retractions or acknowledgements, recovery of legal costs, particularly in UK proceedings under the Intellectual Property Enterprise Court, small claims or multi-track, or in French proceedings under the competent Tribunal Judiciaire, and settlement negotiations for letters before action. Failing to engage with formal legal requests, for example, cease and desist letters, can escalate matters rapidly, exposing infringers to increased liability and costs. However, as the next section explores, these attempts to settle out of court in pre-action conduct are not always successful, most of the time because the infringing brand refuses to take responsibility and acknowledge their acts of infringement. When settlement fails, the sync copyright infringement litigation route is the only other option. While many brands respond constructively to legal notices, others adopt delaying tactics, make derisory offers called nuisance offers, or fail to engage altogether. In such instances, right holders are left with no option but to litigate. In the United States, high-profile cases such as UMG Recordings versus Vital Pharmaceuticals from 2022 illustrate that courts take a dim view of willful infringement on commercial social media posts. This case, UMG Recording versus Vital Pharmaceuticals, which entered judgment on the 21st of July 2022, is widely considered to be the first US federal court case in which damages were awarded for synchronization copyright infringement in social media posts. Here are the key details of this lawsuit. So the defendant was Vital Pharmaceuticals, who is the maker of the drink Bang Energy. The plaintiffs were Universal Music Group Recordings and other record labels. The claims were the use of copyrighted sound recordings on TikTok, Instagram, and YouTube videos without sync licenses. The damages awarded were over 20 million US dollars by a jury verdict. The legal basis was infringement of sound recordings via unauthorized synchronization to visual content in social media advertising. Case closed. This case marked the first time a US court formally awarded substantial statutory damages for sync infringement in a digital social media context, setting a precedent that sync licensing must be obtained even for short clips embedded in commercial or branded social content. It has since been cited in newer US litigation, such as the other cases Sony versus Marriott and the UMG versus Chili's, to underline the legal and financial risks of using music without proper synchronization clearance online. Other notable lawsuits relating to sync copyright infringement in the US are, as I just mentioned, Sony Music Entertainment versus Marriott International, where the complaint was lodged on the 17th of May 2024. The claims were unlicensed synchronization of music in social media content, Instagram, TikTok, by Marriott Hotels. The relief sought was up to 150,000 US dollars per infringement work, which is the maximum one can claim per copyright infringement. And the total claim could have exceeded 100 million US dollars. The outcome was that the case settled out of court and was dismissed with prejudice in October 2024. Of course. Another case is Universal Music Group versus Brinker International. Brinker is the owner of the restaurant chain Chili's. This litigation was filed on the 8th of October 2024, and the key claims were that 80 alleged infringements, 38 sound recordings, and 42 publishing rights used in social media ads. The relief sought was statutory damages up to 12 million US dollars, and the outcome was that the case was settled in May 2025 out of court. For Warner Music Group versus Crumble LLC, it was filed on the 22nd of April 2025, and the key claims are unlicensed use of 159 Warner Music Group tracks on Instagram and TikTok. The relief sought is statutory damages up to 23.85 million US dollars. Another case is Sony Music Entertainment versus the University of Southern California, USC. The filing was done on the 11th of March 2025, so just 3 months ago, and the key claims are 283 unauthorized social media posts using 170 Sony-owned songs across USC's athletic accounts. The relief sought is up to 42.45 million US dollars in statutory damages. And last but not least, Warner Music Group versus Designer Shoe Warehouse, DSW, which was filed on the 1st of May 2025. The key claims are the use of over 200 Warner Music Group recordings and compositions on TikTok and Instagram posts. Relief sought are statutory damages of up to 30 million US dollars. In the UK, the IPEC has become a preferred forum for music-related IP enforcement, especially under its small claims track, which allows music companies to pursue claims efficiently and cost-effectively. While UK case law specifically on sync copyright infringement is not as developed or high profile as in the US, there are several legal principles and cases from the High Court and IPEC that address unauthorized use of music in audiovisual content, including in advertising, social media, and corporate videos. Here's another view. The case Kennard versus Lewis from 1983, the context was that the use of music without permission in a corporate promotional film. It was held that the synchronization of music to video constitutes a new reproduction and therefore requires a license from the copyright owner. The significance was one of the first UK cases to explicitly recognize sync use as a separate act of infringement. The other important UK case is Sawkins versus Hyperion Records from 2005. Although not a sync case per se, the Court of Appeal confirmed that use of music in a fixed recording, even with minor changes, required specific authorization, reinforcing that new uses of music works create new rights implications. Then the case Bourne versus Saatchi and Saatchi Advertising from 1996, where the use of a song in a UK TV commercial without clearance was held to be a sync use in broadcast advertising, and that was not covered by general performing rights, the judge confirmed. A separate sync license was required. This case is not widely reported, but it is referenced in industry guidance by UK music collecting societies, MCPS and PRS. And last but not least, Ed Sheeran versus Shockery from 2022. It's not sync related directly, but it underscores the UK court's willingness to examine musical copyright nuances in depth, especially when used in derivative or hybrid media like audiovisual content. In France, while no fully published decisions have yet confirmed substantial damages awarded by the Tribunal Judiciaire de Paris or any other tribunals in France, specifically for unauthorized synchronization of music on social platforms, i.e. sync copyright infringement, French music right holders, often through SACEM, the French Music Collecting Society SACEM, and other collective management organizations, are increasingly enforcing their rights against influencers and brands who use protected works in Instagram, Facebook, and TikTok posts without licenses. German courts, too, have a track record of enforcing copyright and neighboring rights robustly, especially under the Urheberrechtsgesetz, German copyright law. These cases establish a key principle. Once infringement is established and settlement fails, courts will not hesitate to impose financial and reputational consequences. The practical guidance for brands and right holders with respect to sync copyright infringement is as follows. For brands, always obtain proper licenses before using music in any social media content, even if it's a short clip. Consult legal counsel to understand the distinction between personal use, editorial use, and commercial use. Never assume that platform licenses cover all uses. Check the fine print. Identify infringing content. Audit all social platforms to see if music is used and whether licenses were obtained or wrongly assumed. License or remove immediately. If you want to continue using a track, obtain a full commercial sync license. If not, take the content down. Respond promptly to letters. Refusal to respond may lead to litigation. Even a limited reply, for example, acknowledging receipt, offering to remedy, is better than radio silence. Consider negotiated settlement. Rights holders' letters cap settlement costs. By contrast, statutory damages, if sued, could be much higher. And seek legal advice early, especially under UK or EU frameworks. Harmonizing your defense, fair dealing, exception, can be challenging if the purpose was commercial and audio use substantial. What is the guidance for rights holders? Well, maintain robust documentation of ownership and registration. Set up consistent monitoring of social media platforms using keyword and audio fingerprinting tools and monitor usage actively across platforms and jurisdictions. Issue well-drafted letters before court action outlining claims, remedies, and deadlines for response, where such cease and desist letters are concise, legally grounded, and commercially reasonable. Engage counsel familiar with media law and IP enforcement, and be prepared to escalate to litigation if settlement efforts are ignored or unreasonably delayed. Ultimately, in a digital economy where content is currency, respecting intellectual property rights is not just a legal obligation. It's a mark of ethical and professional conduct, especially for brands who are so aware of their reputation and clout. Crefovi regularly updates its social media channels such as LinkedIn, Twitter, Instagram, YouTube, and Facebook. So check our latest news there and do like us and tweet us back and follow us. Bye for now.